Minnesota is an employment at will state. In this presentation, we'll consider how local government agencies should approach employment at will. Employment at will provisions give employers the right to terminate employees at any time unless it's illegal to do so. There's no contractual obligation to which either an employee or the employer must adhere. Either party can terminate the relationship at any time for any legal reason. This concept reflects the idea that the employer has no obligation to offer, and the employee has no obligation to provide continued employment in the absence of an explicit contractual obligation. While this sounds harsh, most agencies attempting to maintain employment at will do not do so with the intent of terminating employees for frivolous reasons. There are many laws protecting employees from discrimination and unlawful discharge, and many ethical employers looking to maintain those environments. In Minnesota, in addition to the many statutory and civil rights protections, the public policy exception to the employment at will concept is widely recognized. Under the public policy exception, an employee is wrongfully discharged when the termination violates an explicit, well-established public policy of the state. Thus, by establishing an employment at will relationship, an agency is not insulating itself from all employment lawsuits, but it can help prevent messy and unpredictable contract disputes with employees. The implied contract exception to employment at will is relevant when a contract is formed between an employer and employee, even though no written document explicitly identifies the contractual employment relationship. The most common example of this exception occurs when an employer's employee handbook makes representations that are interpreted to be a contract. In order to ensure policies and an employee handbook that don't ultimately imply an employment contract, it's important for agencies to include a clear waiver that the policies in the handbook do not create contractual rights. There are some common public employment situations which are not considered employment at will. They include the following. At-will employees are still protected by various state and federal laws prohibiting discrimination of protected classes or retaliation for engaging in lawful activities, such as reporting illegal behavior or requesting a reasonable accommodation for disability. In addition, veterans are further protected by the Veterans Preference Act. Qualified veterans are protected by law and must be afforded certain benefits from the date of hire. State law provides that no veteran employed by an agency following any required initial probationary period shall be removed from employment except for incompetence or misconduct or the abolition of the position the veteran holds. Employees covered by a collective bargaining agreement or a union contract are not at-will employees. Contract language related to discipline and grievance must be followed. Written employment contracts, or sometimes even oral promises of continued employment, can jeopardize an employee's at-will status. While it's the agency's decision to create contracts with employees, it may make it more difficult to make final employment decisions because of the risk that the contract dispute may result in reversal and reinstatement. Employees covered by civil service rules are not considered at-will employees. Civil service rules governing the removal of employees and employment must be followed. Progressive discipline sections of personnel policies for non-unionized employees where no disclaimer language is included stating the policies do not create contract rights can undermine employment at will. In order to preserve an employment at will rights, agencies should craft their personnel policies in certain ways. For example, some recommend against disciplinary policies referencing just cause. The reason for this recommendation is to make it clear that an employee can be terminated at any time for any reason, so there's no need for anything called just cause. Finally, most agencies maintain employment at will, so if they're ever sued by an employee for wrongful termination, they do not have to show just cause standard, which can be difficult sometimes, even when the employee has engaged in misconduct.